and give the presentation. Thank you and welcome.
Oh, okay, thank you, Carrie. Again, I'm Mike Gallagher with the Water Resources Program in Department of Ecology. I cover our Southwest region, which is Clallam County, all the way down to Skamania County, and as far north as Pierce County. We have a staff of 17 people in the Water Resources section that manage water rights, make decisions on new water right applications, uh, conduct metering, enforcement, um, inspect new wells, and a variety of other activities related to water resources management in Washington. If you can notice on this next slide here, all key point, who owns the water in our state? All water in Washington and actually throughout the West, but each state has a different set of laws which are not uniform across states, but in Washington, all water is owned in common by the people. That includes groundwater and surface water and actually rainwater that falls on the ground. And so a water right to use that water, a right to use that water is to use a beneficial use of a reasonable quantity of public water for a beneficial purpose during a certain period of time at a certain place. And if you have that right of it's being put to a beneficial use for uses, a certain amount agreed to with the state in a water right, and for a period of time, whether it's an irrigation season of say May through September or year round, such as a municipal right, you have that right at the exclusion of everyone else. And so it's not an easy step to get through to attain a water right today, but there's a long history of how it has worked. So a water right itself is a legal authorization to use that certain amount of public water for that designated purpose or purposes. Those are called beneficial uses. I'll provide some more details on that. In Washington state, there's three types of water rights. The first one, or the most important one, or the highest valued one, is a certificate. That's where you've applied for a water right, you've obtained a permit, it's taken multiple, and that's achieved, then the state issues a certificate. And that is actually then filed as a legal record with the county auditor of the county where the water right's being used, and it is considered a property right, no different than owning land. A permit is kind of the development phase of that water right. It's permission to use the water to bring it to full beneficial use, but it's not a final water right. The holder of a permit has to meet several steps along the way, check in with ecology, follow a development schedule, or if they can't follow the development schedule, ask for an extension. And we generally give extensions most of the time. But anyway, it's in a permit phase. And that can take multiple years. It can take a state employee's career of managing several permits to get to full beneficial use. A claim is actually a different type of a water right. It's that I claim that I used water from this stream for this purpose since before the state surface water code of 1917, or before I pumped it from the ground from a well that was installed in 1925 and have used it continually ever since. Those are claims. We have about 170,000 claims statewide. You can no longer apply for a claim, but in the 70s and 80s, there was a window of time when individuals or parties or governments could apply for claims to claim their use of water, and only a superior court can determine the validity of a claim. A vast majority of claims are actually for private wells, which are exempt from needing a water right anyway. So who needs a water right? Well, it's a little different for a surface water source versus the groundwater source. For groundwater, the withdrawal of the first 5,000 gallons a day is exempt from needing a water right for domestic purposes. There's three other exemptions, so there's four of them altogether, and in, I think it's slide 13, I'll touch on the other three exemptions. A groundwater withdrawal, and it's called a withdrawal, is measured in gallons per minute. On the other hand, for surface water, any amount of surface water, even a bucket a day out of a stream to wash potatoes with, legally needs a water right. Now, we don't quite get that small, but if you are going to put a pipe in a stream and divert water out of it for domestic use, you will need a water right. That's measured in cubic feet per second. So any withdrawal or diversion needs a water right. And many of our in-stream flow regulations that we regulate throughout the state were originally developed in the 70s and 80s in an effort to get parties off of surface water and onto groundwater, because pumping groundwater has a lesser overall impact on stream flow than taking water directly out of a stream. There are many uses of water in Washington. They're called beneficial uses. These are a few. The biggest ones are irrigation and municipal supply. That accounts for about 80% of all water use in Washington. But there's a lot of industrial use, water use for fish propagation, water use for stock watering, and all water that passes through a turbine. Just the simple act of passing water through a turbine to generate electricity at a hydroelectric plant requires a water right. That's considered a non-consumptive water right because the water is not consumed, it's just passed through. But these other water rights I've listed up here, these other beneficial uses, are consumptive uses for the most part, especially irrigation, stock watering, and municipal and industry uses. There are several other uses: dairy, dust control, frost protection, mining, etc., but they're used pretty irregularly or infrequently, so I didn't list them on this slide. So how do you get a water right? Well, you or somebody has to answer to our satisfaction these 4 questions. Questions 2 and 3, and to a greater degree 4, can cost the applicant tens of thousands of dollars to answer. Question number 1 is pretty straightforward. Is the use beneficial? If it's on our list as a beneficial use, and there's very few uses of water that are not beneficial, I'll provide one specific example a little later on the slide deck called dewatering, but everything else is pretty much considered a beneficial use. And it doesn't allow wasting of water either, but it's a beneficial use. Is the water available physically and legally? The legally question is the one that's hardest for people to understand, especially the general public, but it falls in line with the form of water law that we follow in Washington state and basically throughout the Western United States, called the prior appropriation doctrine. First in time, first in right. And so if your use is not going to impair a senior user, and in many cases in Western Washington, that includes stream flow, then the water could be available for you. But if it could legally impair a stream flow, it's pretty hard to get a water right without some form of offset or mitigation. Will the existing users not be impaired? So any other senior users in any fashion not be impaired? And an increasing one is proposed use not detrimental to public interest or public welfare. There are more and more parties out there that may oppose a new water right that are using that argument, and that this bottled water plant at this location is not in the public interest. Whereas maybe all the other 3 questions of the 4-part test could be answered satisfactory. And that kind of, in that particular example, that might be more of a land use question rather than a public interest question, but it's being tested out there in the legal world. So if the 4-part test is met and there's no appeals, because we do have a period of public comment and also a period of appeal, then we can issue a water right which specifies the source of water, such as the Clover Creek Advanced Outwash Aquifer or the Deschutes River, and how much can be used. 45 gallons a minute, or maybe 0.1 cubic feet per second, which is equal in value. 1.1 cubic feet per second is about 45 gallons a minute. The purpose of use: multiple domestic, irrigation, dust control, stock watering, etc. The place of use: usually that's the legal description of the property or development, and the conditions: May 1st to September 30th, or January 1st to December 31st are probably our most common periods of use. The first one being an irrigation season, and the other one being just basically year-round use. And other conditions we might provision that water right with, such as metering requirements and perhaps minimum flow restrictions. If the 4-part test is met, there's no appeals, and we give you this amount of water, you have that use forever, at the exclusion of everyone else. But you have to continue to use it. You can't stop using it for a period of time, such as 5 years or greater, otherwise it's relinquished back to the state. So the stages you follow, one follows is you file an application, pay a $50 fee with that. In most cases, you're going to wait several years before we get to your application. But if a party can afford to hire a consultant to do this work for them in terms of doing a report of examination and other necessary work to lead to a permit, that can also be done. A permit is granted, gives you authorization to develop this water right to full beneficial use. Once one has achieved full beneficial use, a proof of appropriation is filed or declared by the applicant or the permit holder, and we certificate that as a perfected water right at full beneficial use. From that top application to certificate can take anywhere from 1 to 100 years. So it just depends on the location, how much water is being used, or how long it takes to put it to full beneficial use, and a variety of other steps. So it's what was once a pretty straightforward process 30, 40, 50 years ago is now a much more difficult process to overcome, because bottom line is the federal government can print more money, but the Department of Ecology, Department of Fish and Wildlife, the tribes, any other element of state government, environmental groups, industry, we cannot make more water. We're all sharing the same pie slice. It's not any bigger, it's not any smaller. It's how it's sliced up is how we manage the resources that we have in our state, which is a much better resource than, for example, Arizona. But anyway, that's the challenge we have, is we share this same slice of pie called our water. How many water rights do we have in Washington? Well, statewide, we have about 50,000 certificates, perfected water rights, and about 3,000 permits in development that are being managed or overseen or checked on by our staff in our 4 regional offices at Ecology on a periodic basis statewide. Probably 2,000 of those permits are in Eastern Washington and 1,000 in Western Washington. And as I mentioned earlier, we have these claims where there was a period of time individuals could file for a claim that they used water prior to 1917 or 1945, depending on whether it's a surface water or groundwater source. Those are on our database as well as a water right, but it would take a Superior Court decision to determine if the claim is valid or not. And as I said, a vast majority of these claims are for rural domestic exempt wells, as we call them, which amount to about 400,000 plus statewide. These are wells that are used that don't require a water right. Or some of the use doesn't require water right, but they might use it also for stock watering, and that would have a water right, or maybe some irrigation beyond a half acre. So out of a well, you can have both non-exempt and permitted uses, depending on what you need. So what are the key laws relating to water rights? Well, there's a lot of them, but the 2 main foundational laws is our RCW 9003, the Surface Water Code of 1917, and RCW 9044, the Groundwater Code of 1945. Those drive a lot of our decisions on water law and water rights in Washington. So water rights, do I need one? For any amount of surface water, yes, a diversion needs a water right. For groundwater only if the withdrawal is up greater than 5,000 gallons a day for domestic purposes, or an irrigation of up to half an acre of non-commercial lawn or garden, or up to 5,000 gallons per day for industrial use, which can be expanded to commercial uses, and for stock watering. Those are the 4 exemptions. I'll get a little more detail a couple slides out. And just to summarize again, our state water laws are based on first in time, first in right premise. Older rights have seniority over junior rights. Does your property have a water right? You might be looking at some rural property you want to buy. Maybe it's a rights database, or you could call us and we could look for you. It does take a little bit of looking, because even though we have a very extensive database, it's not based on modern day 9/11 type addressing. It's based on section, township, range, and a lot of addresses of some of these water rights, and it's based on the property records at file with the county auditor and county assessor's office. And so a lot of times we got to look at the county assessor's records, Google Maps records, and what we have on file to determine, the area of coverage of a particular water right, which at one time may have been a farm that then subdivided into a small hobby farm and perhaps a residential development that's getting water from another source, for example. So the 4 exemptions that don't need a water right: stock watering, no gallon per day per limit or acre restriction. That was understood differently prior to 2009, but the Supreme Court ruled in a decision called Esterday that how this particular phrase in 9044-050 is written and how a comma is in that particular sentence in law, that stock water, it does not have a daily limit. So technically you could have a stockyard in the middle of a rural area, and you don't need a water right for that. However, you're going to have to follow local land use things, and you'll probably be prevented from your idea of, because I don't need a water right for stock water. And that's just for the carrying of stock in terms of consumptive water to drink. It's not necessarily for cleaning or maintaining the stock facility. But anyway, no daily limit restriction. Again, our second exemption, non-commercial lawn or garden of a half-acre size or less. The important thing is non-commercial. So a lot of initial early producers of cannabis wanted to use this half-acre exemption because under the Cannabis and Liquor Control Board, the size of a cannabis grow facility, whether it's indoors or outdoors, is generally a half acre or less. And so they thought, okay, well, I can just put in a well and use that half acre. But the law clearly says non-commercial lawn or garden. Again, no gallon per day limit, but that doesn't mean one could necessarily flood their lawn or garden. It's a wise use of that water. Single use or group of homes, 5,000 gallons a day. That's another exemption. That allows some rural development where you start out with one home and maybe you subdivide your 10 acres into 10 1-acre lots, and each home has 500 gallons a day, which is enough water for parties to live on. However, that same 10 homes has to share that half acre of irrigation. They don't each then have a half acre. It's half acre shared among the 10 lots. And then there's a separate exemption of additional 5,000 gallons for industrial exemption for commercial irrigation. And this has been a recent benefit for, I'll back up to this previous slide. You see this little farm on the lower right with the hoop house greenhouse. So this type of operation on 3 to 5 acres where they have drip irrigation there, you see, if they keep that use under 5,000 gallons a day, that's putting water to a beneficial use for an industrial or commercial purpose, growing crops for profit or for livelihood, then they don't need a water right for that. And so there's a lot of small farm operations that sell to farmers markets and things like that, and they operate that way, and it works pretty well. So it's important to remember that although you have an exemption, all other laws and regulations still apply. You can't irrigate 2 acres by and plot around, like irrigate this half acre one day or this half acre. If you're having a development and supplying commercial or domestic development with water from several wells, all the wells in that development must pump 5,000 gallons a day or less. Anything above that requires a water right. Why is that specific nuance specific to Washington? And we get this question a lot because a lot of people move here from other states. And maybe in Colorado, it's a little different, or California, or New Mexico. And they come here and they buy a rural plot of land, and it's a different story. Well, Washington is not a domestic preference state like Colorado, Utah, Wyoming, Arizona, California, Texas, to name a few. Washington, Montana, South Dakota, Oklahoma, and Nevada have slightly different view of water. It's all public. There's, in Colorado, for instance, you drill a well, you are legally entitled to 350 gallons a day, no questions asked. Now, whether you get it out of the ground, that's another question. But if it's physically there, it's yours. And whereas in Washington, you are legally entitled to have a well drilled on your property, but that doesn't legally entitle you to the water. There is the exemption, but we do have some watersheds in our state that are well under that 5,000 gallons a day, and so it can be more limiting. And so that's where this question comes in. So we are not a domestic preference state. So to get a water right, we have our 4 regional offices: Lacey, Bellevue, Yakima, and Spokane. You fill out an application, submit a fee. It used to be $10. In the last 15 years, it's gone up to $50. Many believe it should be higher, but efforts to raise that fee have not been successful in the legislature because other parties believe that it's, such a basic human right that why charge an exorbitant fee, and it's going to need other fees and mitigation and other studies just to get to the water right to begin with. So it's $50. We receive an application, we stamp it with a priority date. So the day we receive the application is that application's priority date, as if you could use it from that day forward. And that's very important in our prior appropriation doctrine state. So even though we have applications that are 15, 20 years old that we haven't touched yet or processed yet, the priority date is 1995 or whenever we receive that application. And we have about a 5,000 application backlog statewide of pending applications. Again, most of those are in Eastern Washington. In our Southwest region alone of 12 counties and 20 watersheds, our backlog is about 670 applications. One can speed up their application if they can afford it. And, most parties are going more and more this route of hiring a hydrogeological consulting firm or environmental consulting firm that would work with our program's hydrogeologists and permit writers to do what's called a report of examination that we would review and either issue an approval for a water right or deny it. And if we deny an application, the party can appeal our denial. So, I mean, there's legal make on a, pretty much any decision we make under an order or a permit is an appealable document. So seeing their water right application. Generally, the cost of that can be anywhere from as little as $5,000 to in excess of $20,000, $25,000 per application. It just depends on the location, the likely physical availability of water, what type of and a variety of other reasons. So the low end into 20 range. Can I have another well? You want to have a use, you want to water over here instead, or you want to change the season. You can do that through a change application. Again, that requires this whole report of examination process again and appeal process. But you can do that as long as you don't enlarge the instantaneous or gallons per minute amount you want to pump. As long as you don't change those, you can change other things on the application, but it's pretty much like filing for a new application in terms of the steps you have to follow. Can you transfer a water right? Generally, yes. We can transfer it to a new property owner. Those assignments have to be filed with us, and that keeps that permit valid. So Mr. Smith buys this property, has this permit, he sells to Mr. Jones. So we transfer the name of the permit to Mr. Jones. Once it's a certificate, it just stays in the original certificate holder's name because it's part of the land, it's part of the property. Most cases, the water right automatically transfers with the property on the sale of a property, but the seller could choose to sell it separately. So if you're interested in buying rural land that may have a water right, make sure you have the water right come with your sale. Not that people are underhanded in selling it separately, but they have a legal right to do so. And unless they disclose that to the real estate agent who's required to have full disclosure and tell you, it's best if the buyer asks the question rather than expect the seller to divulge the information. Can a water right be relinquished? This is a critical thing. So yes, so if you don't use your water or part of your water at its full beneficial use for over 5 years, you can lose that back to the state. It's relinquished back to the state of Washington. There are other or several sufficient causes in law, such as maybe the water is not available due to drought conditions, or you've been called up to military duty, or you've had legal proceedings on your land that prevented the water from being used, or there's a state program or other federal program that came in and used the water instead that you couldn't use, or you had some varying weather conditions related to irrigation requirements. That helps shield that relinquishment. But still, just about every water right except municipal water use is subject to relinquishment if they don't use it. Same with power development and water being put into trust. Those are the 3 areas where water wouldn't be relinquished. Our trust water program is a way to park all or part of an existing water right into a program that helps stream flow for a period of time while that water right is in trust, but it also helps prevent water from being relinquished. So you own 40 acres, you have a 80-acre-year water right, you're not going to irrigate for 2 years, and to risk losing that to relinquishment, you put it in the trust program for 2 years. It's not used for that period of time, but it's also not subject to relinquishment. And water rights can be purchased or leased. Like I mentioned earlier, you can sell a water right to another party. They can use it. Generally, it has to, in all cases, it has to stay within the watershed, and preferably not so much down gradient, up gradient, but up gradient, down gradient is fine. It depends on the watershed and the location and how much water, but water can be sold to other property owners for use or leased. We do encourage reclaimed water, so that's treated wastewater, to be reused for things like irrigation, industrial processes, toilet flushing. That's like a restroom at a park, for example. You might see parks that are supplied with purple pipe water. Again, that's treated wastewater from their wastewater treatment plant. And rather than going directly into a river or Puget Sound, it's reused a second time to water ball fields at a park, or do dust control, or operate the bathrooms at a public restroom. That's more of a water quality use as well, and the requirements in water quality are pretty stringent. So, but both programs in our agency encourage the use of reclaimed water when possible. We also get more and more questions about rainwater capture. So in 2009, we issued a policy statement clarifying that existing rooftops on an individual piece of land, like a rural residential area, they can collect the water off the rooftop, down the downspouts into barrels, and use that for a garden or lawn watering purposes or animal watering purposes. In a few counties, the one I can think of is San Juan County. It's also allowed for indoor domestic use, but that's a county requirement or county decision. Just about every county in Western Washington, I don't think, allows rainwater collected to be used for drinking water purposes for public health reasons. So check with your county health department on that, but you can use your collected rainwater for outdoor watering when you need to. But it doesn't mean you can then build like a huge pole barn on your property just for the purposes of collecting rainwater only. It's got to be kind of a reasonable collection. We do require with our more modern water rights that they be metered, that we have that meters are installed with each water right. We do also have a pilot study in the Dungeness watershed and Kittitas County area where new wells that go in for rural exempt uses also have to have a meter installed. We actually pay for the meter to be installed, and as part of a 10-year study in those 2 watersheds to see how much water on average is used by rural domestic users. We will be reporting back to the legislature in 2027 on that effort, and the legislature could pass additional laws to either require meters on all wells or not. We'll see what happens. But there's, arguments on both sides of that issue that all wells should be metered. And there's arguments that it's such a small use statewide. And to be honest, all the 400,000 exempt wells in the state of Washington added up use about 3% of all the water in the state. So it's not a large user, but it is a user pretty consistently throughout the state. In some areas, larger than others, especially where you have greater rural. A lot of complaints and a lot of, not a lot of violations, but we do get violations to water law. And believe me, neighbors rat on neighbors. People driving by see something that looks suspicious in terms of water being pumped out of a stream, and they'll give us a call, and we follow up. And we follow up either in person or over the phone or both, or by computer. And generally, we begin with compliance education 95% of the time, whether you call it technical assistance or a warning or a verbal warning or informational exchange. But we get compliance probably 95% of the time. Hey, what you're doing there is illegal. Let's stop that. Don't do it again. Because if we see you doing it again, well, we can take enforcement steps. We can issue cease and desist orders. We can penalize egregious violators of state water law and penalize, thousands of dollars per day if it's egregious enough. And of course, anytime that happens, it's subject, because it's an order, it's subject to appeal. So we got to be prepared for a legal case if that's the case. And we are prepared for it. We have a very good team of attorneys at the Attorney General's office that defend our decisions. And when it comes to that, it comes to that. But 95% of the time, technical assistance does the job. So statewide, and about halfway through my slide deck here, water resources management is this balancing act between competing interests of allocation, people wanting new water uses, new water rights, or transfers of water. Conservation, we're encouraging people to use less water, to reuse water, to measure their water use. Our biggest mission is protection. Our job in the Water Resources Program, first and foremost, is to protect senior water rights. And that includes in-stream flows, that includes tribal water rights yet unquantified, and that includes irrigation rights that are older than a lot of the people, if not all the people on this seminar connecting virtually, or it's older than your working career, and it's expected to last beyond your lifetime. That's our job, to protect that prior appropriation doctrine, first in time, first in right, and to address public interests through long-term land use planning, utility planning, watershed planning, and Endangered Species Act recovery plans to protect fish. A big part of our job, part of that senior water right, is protecting stream flow. Now, we can't protect it against nature and drought years, but in normal years where the stream flow is expected to flow at certain levels throughout the year, we have to be careful that water rights junior to those stream flows don't impair that stream flow. And so we balance that with good objective science of hydrogeology and fish biology and other science disciplines. So that's kind of our water resource management effort in the Department of Ecology's Water Resources Program. We were actually, prior to 50 years ago, we were actually a separate state agency called the Department of Water Resources, which I believe was started in 1917. So it's been around for a long time, over 100 years. I think you've all seen this slide here in your middle school textbook or high school textbook called The Water Cycle. I don't need to go into a lot of detail about it, but it does play a big part in our daily work. And other factors to consider as we make water right decisions or denials. Perhaps the biggest one is location. So that physical and legal use of water availability is different depending on various factors. What's available in the Elwha is not the same as what's available in the Dungeness. It's not the same as what's available in the Sol Duc Ho. What's available in the Deschutes is not the same as what's available in the Nisqually watershed or the Cowlitz watershed, or the Yakima watershed, or the Crab Creek watershed. which is on the Columbia Plateau in eastern Washington. A big driver of that is our variability in precipitation statewide. Just in our southwest region alone, a precipitation can range as low as 15 inches a year in the Sequim area, where we have surface water irrigation that's over 100 years old. Port Townsend area, similar. It's a pretty dry Olympic rain shadow part of the state, to well over 100 inches a year due west of there along the coast, Olympic National Park, western side Olympic National Park, Olympic rainforest area. And for the most part of the region, anywhere from 40 to 70 inches of rain a year. Our precipitation varies quite a bit throughout the state. I live in Tacoma. Where I live, our annual rainfall is about 38 inches a year. I work in Lacey, although with the pandemic, I'm at home, but my office is in Lacey. Average precipitation there's about 52 inches a year. And after 35 years of commuting, vanpooling, carpooling, bus, that distance, I can see the difference. There is a difference in rainfall, even among 12 inches a year when you do that daily. You kind of get a sense of the difference in rainfall. There's a difference in consumptive use throughout the state, but the biggest use is irrigation. 60% of all the water in Washington is used for agricultural irrigation. If you drive across I-90 in eastern Washington and you see those big crop circle sprinklers, now spraying mist water instead of overhead sprinkle spray to irrigate their crops in a big circle. Those are 1,000 or 1,500 gallon per minute wells pumping water from 500 to 600 feet down in fractured basalt to supply water for that crop circle of a square mile or circular mile or whatever the size of that circle is, times a multiple of those in the Columbia Plateau. A lot of that is also surface water being put into those crop circle sprinklers. Our municipal supply for Seattle, Tacoma, Olympia, Aberdeen, Port Angeles, Spokane, Longview, Kelso, Everett, Bellingham, you name it, that municipal supply is about 20% of our use. Industrial supply, the big users, the Boise Cascades, Weyerhaeusers, other large industrial users around the state, the few remaining aluminum smelters, oil refineries, et cetera, that uses about 10%. So that's 90% of the use. The other, and you notice hydroelectric's not on this because their use is non-consumptive. This is consumptive use. All the other uses is about the remaining 10%, and 3% of that 10% is permit exempt wells around the state, the 400,000 plus exempt wells. Another challenge is our demand for water is when the supply is least. That economic principle, supply and demand. Price goes up when the supply goes down. Supply goes up, price goes down. Well, our water use is highest in the summer when everyone likes a green lawn or a robust garden, and the supply is least. The water tables throughout our aquifers do decline somewhat in the summer because there's more pumping, but they do recover in the winter because we have a fair amount of rainfall, at least in western Washington, in the winter. It's a little more dicey in eastern Washington because they have less rainfall and they have less recharge. But this principle applies throughout the state and throughout the West, or at least a good part of the West. There's other parts of America where, a lot of their rain falls in the summertime due to summer storms, and we don't have that type of events in our part of the country. And along with those storms, because thunder or lightning puts a fair amount of nitrogen in the atmosphere, in whether it's Michigan or Missouri or Minnesota, everyone there in the summertime has these gorgeous, vibrant green lawns because of all that nitrogen put in the atmosphere, so they don't need to water their yard as much. But here we have that choice of having a brown lawn or a green lawn. It takes water. But the demand is highest for that water need when the supply is least. And we also have to look at our water supply in the 62 different watersheds or water resource inventory areas around our state. And one way to say it is we have 62 watersheds, 62 different stories. They're all different in terms of their supply, the flow of their river, the source I'll just pick two for an example. So 11 and 13 you see on the map there. 11 is the Nisqually watershed. Its headwaters is Mount Rainier. It's fed by glaciers, and it's also fed by all the rainfall and snowmelt from the high Cascades, the high foothills around Mount Rainier that have a snowpack. And it's got a pretty robust supply of water in that river year round. And then that supply is influenced by Tacoma Power, because Tacoma Power has a couple of dams, Alder and LeGrand Dam, that regulate the flow below the dams. They want to fill that reservoir for power supply. And so the river has a pretty predictable flow year round below the dams. That can fluctuate above the dams depending on the rapidity and amount of snow melt and ultimately glacier melt. Very next to it, just to the west, is the Deschutes watershed. That's a small, skinny watershed. Its source is in the Bald Hills, which is like 3,000 to 4,000 feet, not quite the Cascades, but hills below that are lower elevation. A much smaller snowpack because it's a lower elevation. Whatever snowpack is there is pretty much gone by the end of April. And whereas in the Cascades, the Nisqually snowpack is there through roughly the Deschutes River, for example, near cubic feet per second in January and February and March, and as low as 25 in August. So the supply of water from that river is very fluctuating, and that can also impact the aquifers, although the aquifers in the Deschutes Valley and the Nisqually Valley, where there's sand and gravel aquifer conditions, are still pretty robust. But that's just an example of why different watersheds have different stories. And that can play in with how wells capture surface water. So you pump a well, and if it's near a stream, it's going to take some of that water from a stream. Now, for most exempt wells, like a residential home, it's microscopic or minuscule, but it can be modeled and it can be measured. And our courts have upheld that groundwater modeling showing an impact to stream flow is an impairment. So that's something that where a good groundwater model is our best friend and our worst enemy. But and this is an example of how a pumping from a well or series of wells can dry up a stream. So this is a current ongoing situation at McChord Air Force Base near Tacoma. Clover Creek, for the last 80 or 90 years, or since the runway was constructed there, they piped the creek underneath the runway in two 12-foot diameter corrugated pipe culverts. Now they're gonna change that and have like a 50-foot wide flow of the creek under the runway under an arch bridge. It'll take about a year to do this. And they're currently doing that while they're operating an Air Force base and, planes taking off and landing. So all that's got to be staged. Well, to do that, they have to dewater the water table. And so they have a series of wells here in this slide. If everyone can see that, you see about a dozen wells, maybe more, pumping several thousand gallons a minute. I don't know how they're going, if they're going around the runway or maybe across the runway and they move these pipes. I don't know that, but they have to take that water, dewater both the groundwater and the water from Clover Creek, and then discharge it on the west side of the runway, kind of where that blue arrow is in the slide I'm showing you, the west side there. So they're pumping it from that where it says pumps in the red circle, routing it to the other side of the runways, to the other side, and discharging it back to Clover Creek. So it flows normally from there down to Lake Steilacoom and then out to Puget Sound through Chambers Creek. So in the effort of doing that, they did such a great job pumping that they dried up one of the other tributary creeks that comes into the base called Maury Creek, and a small pond called Maury Pond. You see some dead fish in that pond, unfortunately. So I'm not here to put the Air Force in a bad light. I'm showing you an example of how dewatering works, and that there is this interconnectedness or hydraulic continuity between and a wetlands. That's for our wetlands program and our water quality program to look into and follow up with whatever necessary technical assistance. but we also have to keep in mind the federal government, what they do on federal property. Generally, the Department of Ecology may or may not have enforcement tools or regulatory tools to do that with. But I'm just showing this as an example of, yes, if you pump enough water, you can dry up a creek. And, you know, we have to look at the benefit here. A more free-flowing Clover Creek underneath a runway and kind of an arch bridge environment where there could be some daylight getting in there is better for stream flow and fish passage in Clover Creek. So the long-term environmental benefit, I think, outweighs the immediate environmental cost of what you see here, a dried watershed or a dried stream bed and a dried water or wetland. Anyway, that's a dewatering example. And to dewater, the water's not being beneficially used, so they don't need a water right. So that's one of the few areas where a water right is not needed, where you can pump water. And there's many construction projects around the state, you know, building foundations or bridge abutments for freeway overpasses where there's a shallow water table and you have to temporarily lower that water table to lay the concrete. So you're pumping that water out and you got to discharge it according to water quality standards, but the actual act of pumping and lowering the water table does not require a water right. But we in the water resources program, our hydrogeologists have to look at the subsurface, and we look at it three-dimensionally. And you know, we know that in many cases, areas around the state, we have these shallow unconfined aquifers and lower confined aquifers and confining layers in between, but we also know that it's all interconnected. And this, you know, the surface ground, you see this recharge area, so rainfall comes down and gets through the vegetation and the trees, and whatever's not lost to evapotranspiration, which in Western Washington, probably half to 2/3 of the rainfall that falls gets into the ground and recharges the groundwater, gets into that unconfined aquifer, and maybe over a longer period of time can get into the deeper and confined aquifers. And certainly open spaces is much better than rooftops and pavements to allow that recharge to occur. But it all happens, and then we mine or take that water back out of the ground through wells. And the 500,000 wells statewide are pumping groundwater for a variety of purposes, mostly domestic purposes. But anyway, this view on this slide, which is maybe a 20, 25-year-old view, has morphed into this view. And this is how we see the world today, as driven by water resources management and Supreme Court and other case law. So shallow wells are determined to be not the best source of water because it lowers the water table. So people go to deeper wells. So you go into a confined aquifer well, and even with that, you are microscopically or modeling, taking, like that longest arrow on the picture shows, from a stream that's in another basin, maybe several thousands of feet away or a few miles away, you are taking a small amount of water by groundwater by pumping that well. A well, if you think about it, it's no different than withdrawing milkshake out of a milkshake container with a straw. You see that kind of cone of depression around your straw. That's no different than a well operates the same way. You pump a well, it has this cone 360-degree circle. So it's taking water from all sides into that well screen and up by the pump to the source or the supply that needs the water. That's how water is retrieved out of the ground. It's no different than a straw in a milkshake, to give it a kind of a simplistic effect. But it's one thing to pump milkshake or let's say ice and water mixed in ice, or peanut butter. You can put peanut butter in a cup and then pour some water in it and stir it up and try and pump that with a straw, and you wouldn't get much water. But if you put a bunch of crushed ice in there and water, you're going to get a lot more water out of there. So the pores or fractures in our subsurface make a big difference in how available the water supply is below ground. And this goes back to that previous slide I showed you. Location, location, location. What's available in the lower Puget Sound area, where we have plentiful sand and gravel aquifers with roughly 25% pore space that's filled with water, is a robust physical supply source of water that is a very good supply and very sustainable supply. But let's say if you want to build a home in the Black Hills or the Bald Hills or the Willapa Hills area of southwestern Washington, for example, or the lower Olympics, and you drill a 300-foot well in fractured bedrock and hopefully get to a fractured zone, you're going to recover a lot less water. Case in point, every summer we get about a half a dozen calls in August, September from a private homeowners, homeowners scattered throughout our Southwest region. My well's gone dry. What do I do? First question we ask, where are you located? They're always located in an area where we know it's basically bedrock conditions below them or fractured bedrock. And we basically say, you got two choices. Have your driller or pump company come out to check your pump. Maybe you got a problem with your pump. Or wait till November when it starts to rain again. Because when it starts to rain, those dried up fractures that feed your well will replenish with water. They'll follow the same preferential paths from the surface back down to your bottom of where your well is located and replenish that. But until it starts raining again, it looks like you have a dry well. You're going to have to truck water in or find another water source, maybe a hose from your neighbor. And often cases, individuals, this doesn't happen to them until they really are watering too much outside. So they, in most cases, have enough water for their indoor uses. They think nothing of it. They take it for granted. But then they decide to have a big garden one year or maybe 2 years in a row. And then in August, in that second year, their water supply is gone for a period of time. Anyway, it's an example of just kind of life in a regional office and the occasional or the rare occasion when somebody's well has gone dry. It all depends on what water source, what aquifer conditions your well is taking water from. If it's gravel or a very porous vesicular basalt, which really doesn't exist in Western Washington, but exists pretty abundantly in Eastern Washington. That's great on the Columbia Plateau. That's why you have 1,000 gallon per minute wells in fractured basalt, vesicular basalt. They're just full of water. Or sand or silty sand, you got a pretty decent or very good supply of water for domestic purposes or for municipal supply purposes. But once you get down to that silt, clay, or shale and mudstone, or dense interior granite, or et cetera, where you're hoping for a fracture, you got low hydraulic conductivity conditions and a very unpredictable supply of groundwater. Another case in point, if you know where Summit Lake is in western Thurston County, all those homes around there take their water from the lake with a water right. We're not allowing any more water rights at the present time, but people have tried to drill wells, and there are lots that are across the street from Summit Lake waterfront property that have 600-foot dry holes. So that's one reason why the property is generally inexpensive. Person calls us, why is this so inexpensive? Real estate agent calls and about water supply, and we say, well, it's pretty dicey here. You run a risk of drilling a dry well and spending thousands of dollars for little benefit. Groundwater, like surface water, moves downhill from high to low. Whether it's a shallow aquifer or a confining aquifer, it flows downhill in feet to tens of feet per day. It's not as fast as surface water, but it does move. And so it's continuously flowing from high to low. There's continuously this movement. So unless you're in a big, like confined basin where there's no outlet, you really can't drain the water table. You can lower it, but there's always going to be water from a higher source coming to feed it as it works its way to a lower elevation or discharge point, which for most of us in Western Washington is Puget Sound or the Straits of Juan de Fuca. We have to balance this water management need with the endangered species fish in Washington, which are in various parts of the state listed as endangered species. And as a result of that, we've established in-stream flow regulations in a variety of streams, especially in the tan-colored ones and the yellow-colored ones in our state. Why do we do that? Why do we have these in-stream flow regulations? We're trying to keep as much water in the stream for fish, wildlife, other wildlife, recreation, navigation, aesthetics, water quality, and livestock watering of senior water rights. Not that that takes a lot of water, but they have a water right that's higher in priority than the stream flow regulation itself, with a minimum flow of stream flow. And so we have to protect that right. So any rights junior to that stream flow rule are considered junior. We have these laws that have directed us to work in that way. So with an in-stream flow rule, it becomes a water right itself with a priority date. And anything junior to that, any water rights junior to that are subject to the flows in that stream and can be curtailed. For example, in the Chehalis watershed, there's 93 water rights that are junior to the Chehalis in-stream flow rule. And if we have drier than normal years, we have to notify those water right holders that they have to stop irrigating. These are just surface water irrigation rights. They have to stop irrigating, otherwise they're subject to enforcement or penalty if they continue to irrigate. And for the past several years, they've been compliant. They know they have a junior water right. They accept that reality. And so that's how that works. And that's much more prevalent in Eastern Washington. Why is this important? Well, low flows can affect fish in terms of their ability to migrate upstream, their egg incubation. The lower the stream flow in the summertime, the higher the temperature. Higher temperature increases disease from other critters. It increases the competition for food, increases other predatory species. It can impact the timing of migration of adronomous species. All of that from low stream flow impacts fish. And so we're trying to do what we can to protect stream flow, to protect fish. So new water rights to protect stream flow have to mitigate, which means they have to offset their new water use by a like water use, perhaps buy a senior water right, put it out of use, and use that water as mitigation credit for their new water use. We have a recent Supreme Court decision that basically directs for large water rights, it has to be in kind in place, so the same amount of water. If I have a tabletop here and I take the far right corner, 2 inches corner off of it, I have to replace it with a like corner. That's called 1-for-1 in time in place mitigation. Our program has been directed by court cases more than legislation. People often ask the question, well, why can't the legislature fix this? Why can't the legislature do that? Why can't the governor do this? Why can't ecology do this? Well, we can do things with legislative. We're an executive branch agency directed by the legislative branch through statute to either draft rules or regulations or to follow the statutes as directed by the legislature, and that's what we work with. And because the legislature has been kind of slow, or it's just, quite frankly, impossible, what it gets down to, it's easier to get 5 votes out of the Supreme Court because it's a 9-seat body. 5 votes is a majority. Whether those are votes that help us or hinder our work, there's still a decision by the Supreme Court and they become law. It's easier to get those 5 votes or 6 or 7 than it is to get 49 or 50 out of the state House of Representatives or 25 out of the state Senate, both bodies being 98 seats in the representatives and 49 in the state Senate. So as you know, you got meeting or competing multiple interests in our House and Senate on a variety of things, but when it comes to water, it's very contentious. So to get a simple majority to pass something is very difficult. So as a result, in the last few years especially, we've had these 4 key decisions that have really taken a lot of our flexibility and tools out of our toolbox in making water right decisions.
Hey, Mike.
And yes.
Sorry to interrupt you, but we're at the time to end. So
Okay.
if we could just wrap this up a little bit.
Sure.
Thank
I'll
you.
go to one last slide.
Sorry.
No problem. Sorry, I went a little long here. On top of those, the Supreme Court direction, we also are beholden to some treaties that were signed between the United States government and the tribes in Western and Eastern Washington, but primarily in the Puget Sound area, and that were upheld by the Bolt decision of 1974 and since upheld by the Supreme Court in 1974. That's a US Supreme Court, namely tribes are entitled to half the fish of Puget Sound. To have half the fish, you need stream flow. You got to protect the stream flow to protect fish migration and production. Endangered Species Act, this awareness of interconnectedness between surface water and groundwater, all drive how difficult it is to get a water right decision in our state. So that kind of big challenge of fitting the legal and court-directed statutes and decisions with our variation in statewide precipitation, our different stories in our different watersheds, and our different geology conditions in the ground that we do. And that's it. Thank you for your attention. Be glad to answer any questions. Feel free to send me an email question if you wish.
Perfect. Thank you so much, Mike, for taking the time to present at the IACC online conference. We appreciate it. We've compiled a bunch of questions, and what we'll do is we'll send those to you. And if you could answer them, write out the answer, and then we can post them on the website along with your PowerPoint presentation. And then that way everyone has a link to go to see what the answer was to those questions.
Okay, I'd be very glad to do that.
All right, we appreciate it, and thank you again, and we'll talk to you soon. Thanks.
Okay, have a good day, everyone. Goodbye.